This video, we're going to be looking at a Supreme Court case, Hobby Lobby. You'll be doing a case brief on this particular Supreme Court case and some discussion questions I want you to consider. So I'm going to talk about something that's sort of limited. It was a preliminary question that the Supreme Court had to decide. And I want you to think about this. So I'm going to jump down. So what's going on is you have some closely held corporations. So this isn't the exact definition that you need to be made aware of, but it will be helpful. This is not a publicly traded company. This is a privately owned company, but it is a corporation. There are shareholders, but the shareholders are essentially very few. They're family. And they have some sincerely, strongly held religious beliefs. So this case is about abortion. It is about providing what some would consider contraception, but in a way that these people believe actually abort a fetus. They don't want to have to provide this. But there's some laws out there that says, well, they have to. So you'll get a better background as you read through it. But I want to focus on the preliminary question, and that is, are for-profit corporations, at least for-profit closely held corporations, are they persons under the RFRA? So what is the RFRA? You'll read about that. It is statute. It's the Religious Freedom Restoration Act, but it's a statute that was enacted by Congress in response to Supreme Court decision. So Congress was unhappy with the limitations that the Supreme Court put on a particular case, the Smith case, and so they came back and articulated some additional broader religious liberty protections. And that was in the RFRA. And then there was an attempt to use this and apply it at the state level. And the Supreme Court said, well, maybe this goes too far. So then they enacted the Religious Land Use and Institutionalized Persons Act of 2000. And although that's not directly relevant, although the city of Bernie, Texas is in the Hill Country, near Austin. There was a definition, however, in the Religious Land Use and Institutionalized Persons Act of 2000. And that's what's relevant. And that's what the opinion points out. And so this is highlighted for you. And what is most relevant for present purposes, the RLUIPA amended the RFRA's definition of the exercise of religion. So before this new definition, the RFRA's definition, we'll look here, made reference to the First Amendment. And this is what they said. It defined exercise of religion as the exercise of religion under the First Amendment. And so what they did is expanded it. In the RLUIPA, in an obvious effort to effect a complete separation from the First Amendment case law, Congress deleted the reference to the First Amendment and defined the exercise of religion not as the exercise of religion under the First Amendment, but the exercise of religion includes any exercise of religion, whether or not compelled by or central to a system of religious belief. This definition individualizes the exercise of religion in a way that hasn't been done before. It's a very broad and powerful statement. And then not only did they define it that way, they said, when you're interpreting this, Supreme Court, Congress mandated that the concept be construed in favor of a broad protection of religious exercise to the maximum extent permitted by the Constitution in this chapter or this chapter in the Constitution. So that is key. That is huge. So the preliminary question is, does a for-profit company, in this case a corporation, does it satisfy the definition of person? And so the defendants in this case, HHS, argued that no, it didn't. So the Supreme Court first looks at the definition of person. I'm going to scroll down here until we get to that part of the argument. Knowing that you will be reading this in its entirety to do your case brief, I'm going to focus in on this definition of person. And then there is a second question that comes up. So they're thinking, first of all, that we need to briefly sketch out what is a person, and are for-profit corporations members of the class of persons. So this is, at least in the Supreme Court opinion 3A. So the RFRA prohibits the government from substantially burdening a person's exercise of religion. It doesn't say a state's exercise, which wouldn't be legal anyway. It doesn't say a company. It doesn't say a church. It says a person's exercise of religion. And then even if the burden results from the rule of general applicability. Now that stretch of text is important because of what the Smith case did. But right now we're focusing on a person's exercise. So is a corporation, a for-profit corporation, albeit closely held, is that a person under the RFRA? This is a great example of looking to the text and the definitions. We'll even see the dictionary being used here. So a person. On its face, if you're not a lawyer, it's like a person, well, we probably mean humans. But you know that that's not what we mean generally in the law. Persons include corporations and partnerships and other things. So let's see if that is the case here. Let's continue to read. So the 1 and the 2 here have to do with the test. And these religious tests are extraordinarily important. So we have the Smith case, we have the Yoder case, and we have the Lemon test. We have all sorts of things that you'll be reading about in this course, but this is important. So this is the test number 1 and 2. The first question, though, that they had to ask is whether this provision applies. Whether it applies. And the defendant here, HHS, contends that neither of these companies, that's Hobby Lobby and Conestoga and Mardell, that neither of these companies nor their owners can even be heard under the RFA. So you could argue they don't even have standing yet. This is the wrong way for them to approach this. And according to HHS, the companies can't sue because they seek to make a profit for the owners, and the owners cannot be heard because the regulations, at least as formal matter, apply only to companies and not the owners. So they're saying, hey, they can't win here because they can't be heard. First of all, this doesn't apply to for-profit companies. And second of all, it doesn't apply to individuals because the mandates only apply to companies. This is a good argument, right? Either way you look at it, it's a catch-22. It doesn't apply to them. They can't be heard. We can't even reach the merits of this case because we don't have a right to bring this claim under the RFRA. The Supreme Court, you will see, disagrees. So we're going to do this, an examination of the RFRA's text. And then they literally go there. So as we will show, Congress provided protection for people like the Hans and Greens, these are the owners of the companies, by employing a familiar legal fiction. It included corporations within the RFRA's definition of persons. It's familiar because it's been that way for a long time. They're persons. But it is important to keep in mind that the purpose of this fiction is to provide protection for human beings. It goes on, you'll read through this. It gives a little example. Essentially, what is a corporation for real? It talks about an example of how the Fourth Amendment protection applies to corporations. And then we get to very important. So the Third Circuit, if you have the time, I strongly recommend that you go find this case and you read it. I think it's a very, I say this, well-written opinion. Not saying whether I agree or don't agree with the positions that they reached, but it's a very well-written opinion. So this is just a quote from this Third Circuit opinion. You may be thinking, okay, Third Circuit, I'm getting all these circuits. What does that mean? The Third Circuit is a court of appeals, and losing in the court of appeals, party ask the court for cert, right? Please give us a writ of certiorari. We would like you to hear this case. And so this is the Third Circuit. That's a court of appeals, and there's an opinion in that case, and parties were not happy, at least one of the parties, and so they appealed to the United States Supreme Court, and they had to pray for certiorari. Please give us an opportunity to be heard. And obviously, since we're here in the Supreme Court, they were heard. They were granted cert. So this is a quote. General business corporations do not, separate and apart from the actions or belief systems of their individual owners or employees, exercise religion. Business corporations do not exercise religion. Corporations do not exercise religion. What do they mean? Well, they do not pray. True. They do not worship. True. They do not observe sacraments. True. Or take other religiously motivated actions separate and apart from the intention and direction of their individual actors. So I firmly agree. I am not an expert theologian, but I spent about 6 or 7 years formally studying theology. I have a lowly MA, as it were, in theology, and I have thought long and hard about this. I'm also primarily a business law lawyer. I practice M&A and mergers and acquisitions. I form companies, and I also am an appellate lawyer, so I do civil appellate. But I actually agree. I don't think corporations pray. I don't think corporations worship. I don't think corporations immediately themselves observe sacraments, because I don't think corporations are real. I think they're made up and fictional. The second part is, or take other religiously motivated actions separate and apart from the intention and direction of their individual actors. I agree with that, but that's really, my response would be, and? The Supreme Court says it better than I do. This is what is written in the opinion. All of this is true, but quite beside the point. It's a great phrase. All of this is true, but quite beside the point. Corporations, separate and apart from the human beings who own, run, and are employed by them, cannot do anything at all. Full stop. I love that. I had an opportunity to argue agency and corporations, lost in the trial court, won in the Court of Appeals. The defendant, in this case, appealed to the Supreme Court of Texas, and the Supreme Court of Texas denied the petition, leaving the Court of Appeals opinion as standing, and so we were able to overturn the trial court's legal decision about something. And it wasn't without merit. I just thought we were right, and so did the Court of Appeals, and it had to do with how corporations act. Corporations cannot act outside of human agents. That's what Texas law says, and that's also just philosophically true. Separate and apart from the human beings who own, run, and are employed by them, cannot do anything at all. And then it's just a full stop. I wholeheartedly agree with that. I think it's right. So, how would I argue if I was representing HHS? I think it was interesting. So the court goes on, B1, as we noted above, the RFRA applies to a person's exercise of religion. We therefore look to the Dictionary Act, which we must consult in determining the meaning of any act of Congress unless the context indicates otherwise. Under the Dictionary Act, the word person includes corporations, companies, associations, firms, partnerships, societies, and joint stock companies, as well as individuals. So we have no doubt, this is just a commentary from FCC versus AT&T. We have no doubt that person in a legal setting often refers to artificial entities. Thus, they write, unless there is something about the RFRA context that indicates otherwise, the Dictionary Act provides quick, clear, and affirmative answer to the question of whether companies involved in these cases may be heard. So we continue on. They go through a textual analysis continuing. And then there's sort of this beautiful concession right above that effectively dispatches any argument that the term person is used in the RFRA does not reach the closely held corporations involved in these cases. This is an interesting argument because HHS S concedes that a nonprofit corporation can be a person within the meaning of the RFRA. So they're saying, well, it's a corporation. So if one corporation is a person, how can some be and some not be? Then we get to the principal argument. So I actually find this argument to be compelling. I'm not convinced by it, but I think it's a good argument. So the principal argument advanced by HHS. So these are very bright, extraordinarily brilliant, even attorneys who are drafting these briefs and arguing these cases. And this is the argument they advanced. The principal argument advanced by HHS and the principal dissent, so that's the justices who didn't agree, regarding RFRA protection for Hobby Lobby, Conestoga, Mardell, focuses not on the statutory term person, but on the phrase exercise of religion. So if they essentially lose on person, they're going to try to continue to prove their case. They focus on exercise of religion. I think this is compelling. These corporations are not protected by the RFRA because they cannot exercise religion. So, okay, they're persons. Fantastic. These are not the kinds of persons who can exercise religion. Do you think that corporations, when properly understood, a corporation is an it? Can it worship? Within a Christian worldview, will corporations answer for their behavior, or will it be individuals who answer for our behavior? So can a corporation be saved? Can a corporation be justified, sanctified? I think not, right? It's fictional, it's made up. It's like a comic book hero. Certainly we can talk about the comic book hero, but it's made up. It's not real. So then they go and respond to, well, is your problem because it's a corporate form? Well, you can't really have that argument because HHS concedes that nonprofit corporations, who also have corporate form, can be protected by the RFRA. Well, that actually is the easiest way to answer this. So you might argue that even nonprofit orgs can't exercise religion. Well, they certainly don't worship. The organization itself doesn't worship. It's an it. So it's something to think about. If you're interested in this, maybe there's some other additional research you might want to do. I've actually, this invigorates me, this question. I'm not even sure that a nonprofit organization can worship or take the sacraments, right? Those things are not possible. You have to have humans. But by the definition, or using the definition under the RFRA amended by the LUIPA, I'm not sure how you say that. If you're trying to say RFRA sort of rolls off the tongue. But as amended, the exercise of religion definition, it might be able to. So if the corporate form is not enough, is it a profit-making objective? Is that what keeps them out of this exercise of religion? So they go on to argue additional things. I think that you will find this an interesting case. I also teach business ethics, and I think this is key. Each American jurisdiction today either expressly or by implication authorized corporations to be formed under its General Corporation Act for any lawful purpose or business. I have formed many, many, many entities. My fastest is I formed 31 limited liability companies in 2 business days, on a Friday and a Monday. I have done this a lot. And guess what I put as the purpose? Any lawful purpose. Why? Because I wanted the greatest range of opportunities for these entities I was forming. But we'll see that there are all sorts of lawful purposes beyond pure profit. Can you have a for-profit religious organization? Why not? That's not exactly what they are going after, but they have great examples. I think that you will find it interesting. Let's continue here and get to the resolution. Here's one example since I'm scrolling through. These 2 states permit, these are examples, for-profit corporations to pursue any lawful purpose or act, including the pursuit of profit in conformity with the owner's religious principles. And this is really the case almost everywhere. They're just using some examples to bolster their position. And there's some more argument. Keep going down here. And you may be getting a little bit of premonition that this is a long case. Be mindful that this is a very narrow column of text. If it were full across a page, it wouldn't be quite so long. But I'd like you to look at what it looks like when it's coming down from the court. I think it's interesting. You also have access to LexisNexis, and you can certainly pull these down with headnotes and all of that. You have access as an HBU student to the library online too. So almost there. This is the holding that is important. So when you're looking through your to do your case brief, for all these reasons, we hold that a federal regulations restriction on the activities of a for-profit closely held corporation must comply with the RFRA. What does that mean? It means that these for-profit closely held companies can bring a claim under the RFRA. They're persons and corporations, for-profit corporations, at least closely held ones, are the kinds of persons that can exercise religion. That's what they're holding right here. And when you're looking for the holding of the case, when you're doing your case briefs, oftentimes it just says, we hold that a federal regulations restriction on the activities of a for-profit closely held corporation must comply with the RFRA. It's perfectly acceptable when you're writing the holding to quote this. Do put quotes around it and do cite. If you're doing a case brief, it's not necessary that you cite to it because you already have when you put the citation, but do put quotes, obviously, if you're going to quote the text. But it's that easy. Please do quote the text. The holding here is articulated succinctly. So then we get into the sort of the constitutional claims about the test. So this is all constitutional law about the exercise of religion, but not under the First Amendment, under the RFRA, which was the Congress, that branch of government, separated in its power from the judiciary, trying to balance or check the Supreme Court, who in the Smith case seemed to limit the protections. So this is exactly what we've been talking about. So I'm only going to, I'll end here, but because the RFRA applies in these cases, we must next ask whether the HHS contraceptive mandate, quote, substantially burdens the exercise of religion. And they say we have little trouble concluding that it does. And then through here, they start explaining how. So as you're reading through this, you will see that it is quite long. I meant to stop here. Thought it was on page 42. Might be wrong. Okay, so here it is then. Let's read this. So this will be our last one. The Hans and Greens believe that providing the coverage demanded by the HHS regulations is connected to the destruction of an embryo in a way that is sufficient to make it immoral for them to provide coverage. This belief implicates a difficult and important question of religion and moral philosophy, namely the circumstances under which it is wrong for a person to perform an act that is innocent in itself, but that has the effect of enabling or facilitating the commission of a moral act by another. Let me also highlight this. This is, we sort of ended the question of standing and are you a person? Are you a person that can exercise religion? But this is a Supreme Court case, and it has a lot to do with more than the law. Religion, ethics, law. This is a sort of intersection. Now, this is just a nod, but this is why it's extraordinarily important for you to have a broad, robust education in the humanities and the liberal arts, even if you're going to have a relatively highly technical field, if it's cyber engineering, if it's criminal justice, certainly if it's law or medicine. This is huge. there is a divided country about these things. And those of us who think that life is precious, this is very sort of sophisticated argument here. It's not just a first level intro to ethics course. There's a train, and if you don't switch the bridge on, it's going to kill 1,000 people. But if you do switch the bridge to come down, you turn it on so that it comes down, and you save 1,000 people, you will crush your son who is playing in the gears. Like, what do you do? Obviously, those are interesting questions. Hopefully, no one will ever actually be put in a situation like that. But how do you think about that rightly? It's pretty philosophical. But I just wanted to point this out. You will see more than corporate law in this opinion. And I hope that you actually not only find it interesting insofar as this class is concerned, but that you actually take the time to think hard about this for yourself. And you may come to a different conclusion from me or from your classmates, but I think you owe it to yourself to think hard about this and really try to understand what's going on. So that is Hobby Lobby. And remember, you will be reading the entire Hobby Lobby case and briefing it. And then this question of corporate religious liberty, I think, is a very, very interesting one. I hope you find it interesting as well.